developments in the Manson versus Wood case, on Friday, the judge issued an order. The judge granted Manson's request for early hearing of his motion for limited discovery. That motion will now be heard by the court on August 18th. The court then moved the anti-SLAPP motion filed by Wood the court had scheduled for August 18th to September 13th. As you recall, this case is subject to anti-SLAPP motions filed by the defendants that normally stays the case, stays discovery until those motions are decided, and they can end those causes of action. So the court, however, is also allowed under that statute for good cause shown to allow the plaintiff to engage in limited discovery, if necessary, to show elements of his prima facie case. That's what Manson has asked for here, which is limited discovery from the defendants and some third parties, Manson says, is necessary to make out the prima facie case he has on the claims that are subject to the anti-SLAPP motions. The defendants, of course, resist this, and at the appellate level, there's cases all over the place allowing or not allowing discovery and when it should be and when it shouldn't be. A lot of it is subject to how targeted is the discovery asked for and whether there's anything else in the anti-SLAPP motions that show this discovery wouldn't help you anyway because it would fail in this other regard. So that certainly would be topics in the hearing, I'm sure. So the parties will show up and square off in front of the judge, or I don't know, maybe virtually. Not sure what's going on out there. Either way, they're going to argue in front of the judge about this. The defendants don't want to allow the discovery. The plaintiffs say they need it. What happens when that motion is concluded? If the plaintiff doesn't get the discovery, then they go on and start hearing these anti-SLAPP motions, the first one in September. He'll have to make do with what he has and maybe what else he could file as well if he can get some other things lined up. Certainly Manson has produced a lot of information in support of his current motions. I think maybe enough to get him to where he needs to be, but we'll see. Let's say Manson wins the motion, then what happens? He gets the discovery and moves on to the hearing in September. Maybe, maybe not. That should be the case. However, California courts have actually entertained appeals from a discovery order in an anti-SLAPP motion situation on a writ of mandate. So that's not a normal appeal. That's asking the Court of Appeals to order the trial court to do something. And actually, there was a case involving Bill Cosby, where the plaintiff in that case was given limited discovery, and Bill Cosby filed an appeal for that, for a writ of mandate, asking the Court of Appeals to reject that, saying the trial court had abused its discretion and misapplied the law. The trial court in that case stayed the order until the appeal could be decided. So if discovery is allowed, the defendants had their eyes on potentially filing this kind of writ. I don't know whether they will or not, but it could slow the case down again. If that happens, it'll have to be decided on appeal. If not, then there'll be discovery before the September hearing if the motion for limited discovery is granted. Then in September, the court's going to hear this anti-SLAPP motion, think about it, and decide on it. Either way the court decides in that situation to grant or deny the anti-SLAPP motion, it can be appealed. And when it's appealed, it will normally result in the stay of the case. However, if there are causes of action that aren't dependent on the things decided in the anti-SLAPP motion, those could continue. And given the way Manson's attorneys have drafted this lawsuit with the kind of claims that are in it, that are not like the Johnny Depp lawsuit claims, that's in another video, but I'm just telling you because it may matter here. It is possible the court could allow some of those claims to go forward even if the anti-SLAPP situation is on appeal. So we'll have to see. More likely the court would stay it all just for the convenience of the parties and the court, that we don't need to be piecemealing this thing out twice. But it's possible it could be split. So either way it goes, you're probably going to see an appeal after the September hearing decision is made, and then also the same thing when the Gore hearing is made. But what is going on right now is some actual action in the case that the court's going to listen to these guys talk about whether they're going to get discovery or not get discovery, and get on with hearing these anti-SLAPP motions to see this case move forward. That's the breaking news. Thanks.